Afternoon, everyone. We welcome you to the second day of this international event. Thank you for accompanying us, and a special thanks to our guest today. Yesterday, we had the pleasure of talking with activists and advocates of human rights, academics committed to legal abortion, to the right to legal abortion. It was an enriching conversation, which gave us food for thought about lessons learned and the present challenges for the access to legal abortion. As we said yesterday, Argentina has the law for the voluntary termination of pregnancy, which recognizes the reproductive autonomy of women, the access to legal abortion from a human rights perspective. Today, the starting point is the right to choose freely over our bodies and the project, the life project we have. This happens while in other sectors of the world, conservative groups try to step over the rights of women. That's why yesterday, we problematized the regression in the access to SRR in the USA, one of the countries who was at the forefront in the second half of the 20th century, mainly in the recognition of the right to abortion after the Supreme Court ruling of Roe v. Wade in 73, which established a baseline of rights, hoping that the broadening of rights would gradually take place. However, the other side of all this progress in terms of human rights is the reconfiguration and strengthening of anti-right groups, which renew and sophisticate their strategies to hinder the access to legal abortion. That's why yesterday we agreed on the relevance of keeping up activism and the mobilization of the Green Wave permanently and demand the accountability of the USA in terms of public policy for the access to SRR. We talked about the importance that a law is not enough in itself. We need a strong strategy of communication to prevent the anti-right groups from controlling narratives. All the panelists yesterday agreed that it's a priority to keep up the fight for reproductive justice. It's not enough to recognize the right to abortion if we don't adopt necessary measures for nobody to be left behind. That's why we pointed out the intersectional outlook in the development of policies which include racialized people, migrants, indigenous populations, trans, intersex, and people with disabilities on equal conditions, since it is those people who face the greatest barriers in the access to their rights. We also pointed out the importance of facing gender stereotypes that are still reproducing maternity mandates on the role of women. It was particularly interesting to listen to the Irish experience to anticipate the possible attacks that we can expect here in Argentina or in other countries, and also to point out the relevance of information campaigns, public information campaigns, which were in turning points in the access to rights in that country. Since the legalization of abortion in that country, as our colleague in Ireland was telling us yesterday, more than 30,000 women had access to the determination of pregnancy, which had an impact in the access to health from a human rights perspective, and it had a positive impact on the GDP. We add to this the context of pandemic, which demanded a reconfiguration of strategies and the promotion of access to abortion through telemedicine, an important progress in guaranteeing the access to the termination of pregnancy. However, we also mentioned yesterday that there are quite big legal loopholes and barriers in the effective access. That's why we need to identify and monitor, diagnose the challenges to face the resistances in the rights. We have to keep on strengthening alliances with the organizations of civil society committed to the struggle for legal abortion. We need to have resources and share resources for the legal empowerment, promote strategic litigation, and communication campaigns which guarantee the access to information to make free decisions, informed enough over our bodies. Today, we want to keep on deepening and reflecting on these aspects with the valuable participation of Isabel Jaramillo, tenured professor of the University of Andes. She is the coordinator of Latin American academics working on gender, sexuality, and identity, the famous ALES network. Siri Gloppen, director of the Michelsen Institute of the University of Bergen, Norway, and Rebecca, Professor Emerita and co-director of the International Reproductive and Sexual Health Law Program in Toronto, Canada. We'll start with Isabel. My first question is this. The step taken by Colombia in 2006 through the Constitutional Court ruling that repeals the absolute banning of abortion was progress towards the protection of the dignity, life, and health of women. This established a precedent and contributed to the normative developments in the region, placing the human rights at the forefront. In your book, you talk about the process of progress and resistances which have to do with the broadening of rights in the legal and social political field. This demands a sophistication in legal arguments and the strategy of campaigns. What are the present and current challenges in the fight towards legal abortion in Colombia? Thank you, Mariela. It's an honor to share this board with Gloppen and Cook, who I really admire. In the Colombian case, I'd say there are two things that call out attention. One was the repertoire displayed to accomplish the effectiveness of the ruling of 2006. As you pointed out, they considered the absolute ban of abortion unconstitutional, and they introduced what is called in comparative literature a model of indications for abortion, that is, causes or causalities through which we can justifiably or legally terminate pregnancy. This was identified as a problematic model since the definition of causalities, the determination of whether the women go into or fit these causalities, required multiple requirements, which made this impossible. That was the Latin American experience until 2006. So the litigation in 2006 had to anticipate strategies so that it wouldn't be stuck in the places and situations of all the rest of the countries in Latin America. Before 2006, Colombia, Chile, and El Salvador had this total banning without any causalities. The other countries already had causalities. So the challenge for feminists was to think about this. We deployed, I think, a series of strategies which were intelligent to maximize the political opportunity opened by this model, which we already knew was a difficult, controversial model, but which brought about opportunities to change the way in which the termination of pregnancy could be negotiated in Colombia. I'd like to point out very quickly, because I know your question takes us to the present mainly. I'd like to highlight some things that were done. A regulation of the ruling through administrative norms to give its importance in front of those who are at a lower level and don't read the Constitution, to show that this was not just a ruling but a norm to accompany women who request the interruption of pregnancy and who obtain negative responses, generate litigation where this is denied, and finally, an active control or revision of courts and the National Congress to hinder the initiatives of the right-wing movements in Colombia. In most of this, as we said in our last book with Ana Cristina González, in all these aspects, there was a lot of success in the strategies. It is impressive how in the Senate, the conservatives were cornered and had to say that they couldn't invoke God in the parliamentary debates. That was their only argument. That was the only one they had. They knew it was useless. The fact that they admitted this, they said the debate doesn't allow us to invoke God, is a success. That was one of the successes that we referred to. All these successes, but however, what is it that we still face. What have we been able to document? But behind all this, we have a documentation activity of everything taking place, not on the part of the state, who doesn't have official figures as regards the number of abortions in the health system. They don't even know how many take place outside the health system. They had to gather information on what happens to women when they get to the health system to request the termination of pregnancy. So what we have there is a medical community that is hindering the access of women to services. This brings about, on the one hand, that most of the terminations of pregnancy that get to the health system are those where the intervention of doctors is unavoidable. That's why there are many early pregnancies carried out through drug treatments. It has to do, and the others have to do with advanced gestation processes from 22 weeks onwards. Those who get into the health system, for the doctors, they're more difficult to understand, more difficult to perform. They're not trained enough. We have been working on this as well. But transforming the mass of doctors has been quite difficult. I'd say there are two reasons why it's been difficult to transform them. It's been difficult also to document this. I think it's difficult to document because doctors don't want to answer questions. They consider that if somebody begins an investigation or somebody who tried to carry out an investigation, that if they are identified as those who perform abortions or anti-abortion ones, this is so delicate that they may lose their family relationships or their jobs. Therefore, they don't want their position to be known. And those doctors who are in government positions think it's important to offer services, transform the way in which the cases are taken care of, face resistances that are almost inexplicable. They don't understand why a woman has to sit in a room for 3 days and later say that she has to leave, and they don't explain anything of what has taken place. These are situations that we are facing. Therefore, there are barriers in the medical community that don't want to deliver services. There are a few providers, private providers, who request payments, but this is a service guaranteed in a health system. Therefore, there is a privatization of the service that it doesn't go along with what is in the legislation. What do we think about doctors? Well, some hypotheses are that they work weakly as a community. There are no clear leaderships. This system is plotted at a proletariat level. They have worked with many doctors, but these doctors haven't been able to transform the common sense of everyone. On the other hand, we have a weak supervision, ethical supervision of doctors. They kind of control the ethical courts. I'd like to mention also the criminal persecution of women who terminate their pregnancies. In a recent study we carried out, hired by the Board for the Life of Women. I was the main investigator. I'm not part of this board for life, but I collaborate with them. We found out that in the last 15 years, there has been an increase of the persecution of women due to abortion, and we defined persecution due to the number of reports, the cases reported by police to the DA's office. They have gone from 199 in 2006, and they went up to 489 in 2009, and they keep a stable level. It seems a small figure if we compare it to what happens in other investigations that says that there are only 400 abortions carried out in Colombia. The operation of the criminal system would seem sensible if we compared it with other crimes, because the persecution is quite big, it's a persecution where doctors and the health personnel has a central role. In the announcements, in the reports to the police, where half the cases are opened, these are communications that are made by people who see women arriving in a situation where there is a risk to life. The doctors, the directors of hospitals, nurses, even social workers or security people, as responsible citizens, make a call which ends up in the arrival of the police. This is quite serious because it means that for women, doctors, it shows us when they get to the doctors uh, and there's a complication to their life, they are being stigmatized. So much so that the case is taken to the police. The other point is that there are not many women who go to jail due to this, from the figures that we have, because the penalty is from 2 to 3 years. There are around 40 rulings a year, and the ones who are sentenced are from 14 to 18 years. They're a relevant number, but they don't have the same sanctions, but there is an overrepresentation of the underage women in this group. What type of causalities, what circumstances do these women find themselves? Does it include rural women? We don't find it in our study, but we can find this in the DA's office investigation. They appeared maybe as women of interfamily violence. They were identified maybe in rural areas or far away from the urban centers. This is the persecution of the more vulnerable women of society. Isabel, I wanted to ask you, we had good news in Mexico a week ago. There are very interesting Mexican news in terms of going forward with the decriminalization of abortion in Chile too. The last few days, we had some progress. We don't know how it will end up. What impact does what happening here in Mexico have in Colombia? Do you think it has some impact? Yes, definitely. Today, we have the debate in the constitutional courts, in the Board for the Life of Women, accompanied by other organizations. They presented a lawsuit to open up the debate again and requesting the decriminalization of the conduct. This is a lawsuit that has existed for a year. It's quite a long process. And it's being delayed because the right wing has intervened in the process, requesting annulments. It's strange in the constitutional process, but they need to attend to these requests, and we have had 8 or 9. The court needs to resolve this. I think it's a very good sign that the region is going forward in the liberalization of the legal framework, since it shows that we are not isolated as a strange country that is doing something radical. In fact, we are immersing ourselves within the common sense of the region. We are within the common sense of the region. However, what has been approved is the weak models is not good for us, because given the conditions of the Colombian system, this weak system is so risky, is risky not to be accomplished, or runs the risk of not being accomplished. Maybe the health services don't attend to them, and it may be similar to our present system. There's a mixed sensation. On the one hand, it's quite positive. It shows the common sense of liberalization. On the other hand, it gives us a sensation that the trend is to create a weak model. And in this weak model, there's quite a lot of risk. In some senses, it could be more of a regression than an advance. So I think we take this with a lot of enthusiasm of seeing how feminists, all these big changes, mainly through Congress laws, which tackle a specific point of the criminal law. They address the sexual rights better. They accompany the transformation of Mexico, where we had processes of toughening of the criminal law. These transformations are quite positive. So I'd say it gives us the bitter sense of what is being decriminalized is a weeks, and not as it was in the Argentine process, where it was a total liberalization followed by medical norms with other parameters.
Thank you so much, Isabel. I now move on to Siri. Yesterday, we spoke of the backlash from the anti-rights movements, and we reviewed the case of US, Ireland, Argentina in a global context in which political moral battles move to courts. What does this mean, and what is the role of civil society in this scenario? What specific examples do you think are relevant to be shared? Siri, are you there?
Yes. So I first want to just thank you for inviting me to this very distinguished panel and super interesting and important discussion. And I also want to congratulate Amnesty and the movement in Argentina on sort of on moving the sort of struggle ahead and having some really wonderful advancements and victories in a situation that is sometimes just feels very challenging. So thanks a lot. I think that also, I mean, I want to just start with Argentina, because I think that so you asked me about the battles that moved to court, but I think that the Argentinian case also shows that there are other arenas that we need to sort of see the interlinkages between the different arenas, and that the battle that has been advanced through the legislative channel, the streets, the arts, the multiple arenas that have been used to change people's thinking, the dialogical arenas, that is something that is super important. And when I will talk about sort of what goes on in the court, but it's very important to think about this as arenas that are interacting and where there are many advantages of fighting these battles in the broad public sphere and in the legislative arena. And I think not only Argentina, but I think Latin America as a whole, even where, as in Colombia, the courts have been sort of where spearheading in many ways, there is also this broad public mobilization. And I think that is super promising. I'll come back to it later, but I'll try to unpack the question that you're asking about why do we see these political moral battles moving into the courts in so many parts of the world. And I think that, I mean, first, of course, it has to do with the rising political salience of what we can call politics of morality across the world. And I think, and of course, in addition to abortion, LGBTIQ rights are very striking. I mean, these are the main issues in what we sometimes see as a culture war. So it's, but there are many more, but these are sort of, they've become markers of political identity with an extremely high political value. So if you tell me your stand on abortion, I can know what you mean on a lot of other issues. So there are these political markers, and they're really valuable politically in terms of mobilization, but also coalition building. and there are a lot of there is a lot of sort of political currency in this. So the stakes are high, and that is also why they move into the courts. But they don't only move into the courts; they move into all of these arenas at the same time. And of course, we can talk about why they've become so important. And I think that is, I mean, many different answers to that. But of course, it's also partly a response to advancement of liberal values, advancement of feminism, liberation of women in many parts of the world. Also, this blurring or breaking down of the distinction between the private and the political, and I think and then it is a challenge. I mean, that is a movement that challenges patriarchy and that challenges sort of traditional ways of understanding the family and society. And of course, so there is this. It's a broad battle, a legitimate in a way, political battle between very different ways of seeing the world. So I think there are these. I mean, there's these heavy structures, and then there are more tactics that also explain it. And of course, one of the things that have been happening in this, in the past 50 years, is that we've had sort of a turn to rights language. So a lot of the feminist advancement has been in a rights language. And this is a broad movement of human rights, rights talk that also makes courts easier arenas to use. And of course, courts have become stronger. We have international treaties, national constitutions, courts with strong powers of judicial review in many more parts of the world. So they're there to be used. It's easier to see the courts as arenas for these types of battles. And what we see, not everywhere, but many places, is that the courts are particularly used by those who can't see that they can win through the legislative process. So if you don't have the numbers or the political elite, even if you have the numbers, the political elite is too strong to allow advancement. The courts are in sort of a liberal age easier to use for advancing the cause, if it's a liberal cause. So I think what, again, speaking in sort of big letters, I think what we saw was that sort of the both in terms of sexual and reproductive rights, but human rights more broadly, it was the progressive movement and the progressive part of civil society that used the courts more, also individuals. But also over time, what we're seeing is that, and then often the pushback came by political bodies. So you would get an advancement, and then the legislative process or constitutional amendments would undermine, and you would have this back and forth. But also what we've been seeing over time is that the antis, the conservative side, are also using the same tools. So they're learning. There is this learning across. So they're also using rights language, they're just twisting it a bit. They're talking about the rights of the fetus, and they're talking about other types of rights and other ways of using rights. They're talking about rights to freedom of religion. They're talking about conscientious objection. They're talking about things that are also rights. So they're using they've learned to use the legal tools. So in a way, it's in a context where, as in Argentina, the advancement is in the legislature, as it was in Norway, where the advancement is in the legislature. There are, of course, and where it might be more tempting for the opposition to use the courts. So it's just important to realize that there is this broad battlefield, and it's an iterative game where it goes many rounds and it sort of moves around. So rights and law are sort of used across the big field. also in the administration, so in the policy field, and also return to that. But I think that that is one thing that's really important. And also, what's important is that, so it's a learning across, but it's also a transnational learning. So it might be that. So in a way, I mean, if we think about the US, in a way, it seems to be this sort of internal process where we have this back and forth, and it seems to move, and we can see the pattern. And also in some Latin American countries, in other countries, like for instance in Africa, we can see that a lot of these court cases don't really. They also have an internal. There are internal processes, but they also have a stronger external push often. So, for instance, if we look at most of the African cases, but also in India, in some parts of Europe, but particularly in Africa and India and Nepal, we see that, for instance, in the abortion field, most of the cases are directly or indirectly sort of involve the Centers for Reproductive Rights. So it's a very sort of learning on the progressive side, often by human rights advocates in the country, but there are alliances that are very important for why you get the cases, if you look at it more closely, like strategizing with some civil society organizations who are then doing the litigation and advocacy. So that is interesting. And in some of these cases, in some of these countries, we don't really know what that is going to, what it's going to jumpstart. But what we're seeing is, and it plays out very differently, but what we see in some countries is that it seems to sort of also put sometimes the courts at risk of becoming more conservative. That is, of course, what we've seen in the United States and also elsewhere, is that, so once the legal arena becomes useful, you also try to look at how it is constructed. So, of course, the progressives have tried to sensitize the courts, to sort of influence which judges are being appointed and so on. But the conservatives have also been really good at that game. And of course, in the United States, that has been important in terms of influencing legal education. It's been important in terms of influencing appointment processes. And I think that is also something that, so while the courts were in many countries, the courts have been the most friendly, even if not always friendly, but the most friendly forum maybe for liberal arguments, we also see that there are sort of more successful attempts at making some of these judiciaries more conservative. But again, I mean, this is not always happening, and it's very contextual. So I've been talking in big letters, but there is something there that we need to think about. That maybe in some cases the advancement of the cause might not necessarily be done most effectively through litigation. I also want to I know I've been speaking a lot now, but there is one more thing that I would like to sort of point to, and that is that we need to also maybe be realized or think more about the way in which the battle is constructed, if you want, because I think so. Also on the progressive side, there are a lot of progressive causes that have been advanced over the decades. So we were talking about abortion, LGBTIQ rights, which are, of course, a lot of different things, from decriminalization of both to marriage equality, recognition of legal gender, gender-affirming surgery, adoption rights for men, in vitro fertilization. There are a lot of issues. that are connected around sexuality. So sexuality and gender is like this big and diverse set of causes that has been advanced. Also around marital rape, child marriage, gender-based violence. So this is like a big set of cases that have been advanced, often by quite different groups. So on the progressive side, there are many sort of dedicated movements and dedicated organizations working on all of these different rights. But if we look at the conservative side, there is a lot more cohesion. So for the conservatives, often the religious right, these are deeply connected. So these are issues that are related to the role of God, but also the role of the family and society, the natural order of things, and so it's much more sort of strategizing across, which means that in some countries the same organizations might focus only on abortion. In other countries or continents, I mean, on the African continents, it's absolutely mainly LGBT rights, much more than abortion. But then again, there are also more issues that are connected. So what we see, for instance, in Europe is that what is also part of this same front are issues related to child protection services. I mean, Norway has an enormous amount of cases against Norway, the Norwegian Child Protection Services, in the European Court of Human Rights. And a lot of them have amicus from, for instance, the Polish organization called Ordo Juris, which works mainly against abortion, and against LGBT rights, and against the Norwegian Child Protection Services. And the sort of state feminism of the Scandinavian countries is really sort of part of the enemy, and that is part of this sort of focus on gender ideology as a big enemy. So this sort of the gender ideology that is seen as sort of the liberal force or the destructive force in society. So that's sort of clearly, and homeschooling is part of this same focus. In addition, and that is more on the coalitions, we also see that there are a lot of other battles over liberal values that also sort of form part of some of these conservative movements that are also on the role of the state, and particularly in the United States, but also I think in some parts of Latin America. It's also around gun laws, vaccines. We know now a lot of mobilization around vaccines, climate change, but also around migration. And that is where there is also a lot of coalition building. So I think that is one of the things that we as progressives and who want to sort of, even if while we sort of focus on a certain more limited set of issues, most organizations, of course, some like Amnesty is our border, but still I think it's important to just sort of realize that we're up against something that is a lot more cohesive and adaptable, that is adapting very differently in different contexts. And that, so yeah, so I don't know if I see I should probably stop now, but I'll leave it at that, and then I'll come back later.
Tengo muchas preguntas de todo lo que dijiste, y tal cual como vos.
I have so many questions arising from your comments. As you said, in Argentina, once the law was passed, 35 legal actions were started against the act. 19 of those were rejected. They were not admitted because they were illegitimate, because justice understood that no one can claim to represent unborn people, as they said. And in your presentation, I think you mentioned that. So what are the most effective arguments to answer this conservative backlash against abortion, our abortion conquests. Amnesty Argentina, in alliance with organizations leading gender efforts, we defend the law through strategic litigation. We are very involved in these legal actions with our partners from the O'Neill Institute in Georgetown University, and we are very careful to fight this litigation. In your experience, what have been the effective arguments against the legal attacks that want to remove the right?
So in some ways, I mean, this is, as I said before, I think it is very important that it's, I mean, this is very contextual because there are different, I mean, each context is different. But I think that, I mean, what we see, there are sort of certain types of challenges that are there. So, of course, there are the challenges against constitutionality that go around the right to life and the rights of the fetus and so on. And I think in some ways, in a context like Argentina, those are the least dangerous in a way. And I think that is also because you had a really robust democratic process, and I think that and I think that also sort of emboldens the courts to not to sort of to sort of not necessarily to not sort of take those claims. I think that's the least vulnerable. I think that is where the courts would sort of yield to the very sort of thorough democratic process much more easily, particularly where there is a highly mobilized civil society. I think there are other types of challenges. I think what we see a lot, and in many countries that have more or less legal access to abortion, or broader, or either as broad as as you have now in Argentina, or the more indication-based model as in Colombia. I think that the biggest challenges are those that hinder access, where you have I think conscientious objection is everywhere. That's what we're also seeing in Norway to some extent, and that is that, and I think those challenges are difficult, but I think that Claire, and I think Isabel spoke to that as well. I think that the clarification of the conditions for conscientious objection, that is clear, that professionals know what they can do and can't do, and that there were and that the sort of argument to try to, I think one of the things that have been very important in Norway is to hinder that institutions, hospitals, clinics can't have conscientious objection. They must always have someone who can, they have an obligation to perform the service. But so individuals can be on limited grounds, can have an exception, but not an institution. And sort of, I think that is the type of challenge that is important to fight. I think, for instance, in South Africa, which has a liberal access, a very, very high number or a very low number of public clinics actually provide abortion. There is a vast and very sort of messy consensus objection practice that isn't properly regulated. So I think that is something that is really important. Also to have clear sort of ethics guidelines for the health practitioners, to have a sort of to work with the professional organizations is also important, and to demand sort of clarity of procedures. I think that is is super important. And then I think that there is, and then of course the third set of cases that often come are on the sort of erecting procedural and practical barriers to abortion and erasing the emotional costs of abortion. And of course, Isabel also spoke to that. And I think that is and again, I think that's easier to fight if you have a highly mobilized, society. And I think, so we don't, in Norway, we don't really do a lot of things through the courts. We have some conscientious objection cases, but we don't have a lot of it in the courts. But when we've had sort of political coalition building that has tried to do something with the abortion in sort of the indications after the first trimester, then there are indications. And when there has been attempts at trying to restrict, what happens then is that there is a huge mobilization potential in civil society, so that it actually has led to expansion instead of the attempts to sort of tighten the conditions. And I think that to sort of meet the legal challenges also with social mobilization, as I think you're doing very well, at least for now, but of course it's a challenge to keep mobilized. But I think that is extremely important. Of course, there are legal strategies that can be done, but I also think that to sort of work with at the policy level, both within organizations and within health ministries, is also really, really important. Sort of use strategic litigation, but also use diverse strategies that are less red flags. I mean, in many countries, for instance, in Ethiopia, where abortion is criminalized, and where in effect there has been a big broadening because they sort of made a really wide rape indication, where you didn't have to report rape, you didn't have to the police or anything. You could just on very liberal. It was sort of very clear that it was widened to provide easier access to abortion, but where they didn't want to do it because they were fearing the very strong church. And I think that also it depends on where you are. And I think where in a more secular society, it's easier to sort of move the law. And I think if you can move the law through parliament, it's easier and more robust. But if you can move it through the courts, that can also be useful. But you know that if you move it, there will also be you will also have to sort of deal with the response that is coming, both in the courts and out of the courts. And that's why the social mobilization is so important, and also the social mobilization that points to the injustices and intersectionalities in this whole situation, where young people, sort of pregnant persons who are young, who are poor, who are maybe rural, are so much more disadvantaged, so that you can also have a sort of a social mobilization around this, and a social argument around this, both politically and also in the courts.
Thank you, Siri. Thank you, Siri. I'm going to español. Voy a Rebecca ahora.
Thank you. I'll go to Rebecca now. But I have two questions for you later to think about. One question is, do you think that a law like the one in Argentina, which is quite progressive in relation to Poland, well, even Nordic laws, or the one in Germany, if in Europe they started thinking, well, shouldn't we reformulate our own legislation because we are falling behind somehow? The other question that came up related to what you said, don't you think that the country from which the Pope is from, the Argentine Pope, decriminalized abortion? Isn't it an incentive or other very Catholic countries can politically start thinking and say, well, if it was done in Argentina and the Pope tolerated it, why wouldn't he put up with this in other countries? So I'll pass on to Rebecca now, and I leave you to think about these other questions. As we were pointing out yesterday and today as well, while in the USA and in Europe, in Western Europe, they were more at the forefront of the legislation reforms related to abortion. Today, it's the trans-feminist Latin American movements, the ones who are going forward in these arguments, right? They put at the center of the scene the reproductive autonomy and gender justice. The law sanctioned in Argentina takes up experience of other countries. We take models of other countries. We incorporate the lessons learned in other countries and feeds back from judicial debates around the world. At the same time, we know that the legislative reform is only, as Siri mentioned, a step in the progress towards effective access or implementation to abortion. So, Rebecca, what is your viewpoint on the transnational scenario of the last few years? What success cases do we have? And what are the pending challenges? On the other hand, what complementary strategies should accompany the legalization of abortion? Siri mentioned some, but we'd like to listen to you mainly around the conservative backlash.
Well, welcome and greetings and congratulations. Isabel, I enjoyed your talk tremendously. And Siri, I always learn a great deal from listening to you. It's been much too long since I've seen you in person, but it's lovely to see you both virtually. And I want to just extend my congratulations and underscore what a victory you've achieved in Argentina. It really is inspirational in many, many ways. So in terms of your questions, Maria, what are the strategies, just to build upon the conversation you had before about conscientious objection? I think our movement has missed a very significant opportunity to talk about the right of women's conscience, the right of women to call their souls their own. And here, I think we have a lot to learn from the situation in Ireland. In particular, the rewriting of a very important decision in Ireland, the McGee case. Mayron Enright rewrote a decision, and she accorded she accorded Mrs. McGee her right of conscience, her right to call her soul her own. So when we think, even in the Argentinian law, it's framed as conscientious objection of the provider without regard to the right of conscience of other people involved. And I think as this issue arises in Argentina, which I gather in some of these cases it has, you have an opportunity to reframe the debate and talk about the right of doctors to provide abortions, the right of conscientious commitment, as well as the right of women of their own conscience to call their souls their own. And Mayron Enright's rewrite in the Rewriting Judgments book of Ireland is, I think, absolutely brilliant, and how she rewrote the McGee case, which threw out Mrs. McGee's claim for her own right of conscience. Mrs. McGee wanted to access contraception based upon her right of conscience. She won the case, but she won it on grounds of right of privacy, not on her right of conscience. The court, this is ages ago, threw out that right. And I think that was really very, very problematic. And just think about if the court had accorded her right of conscience, how the development of the norms around conscience would have been very different today. So I think in Argentina, you have an opportunity to reframe this right, not only as one of doctors to object, but as doctors to commit to provide services, and of women to their conscience. So that's one strategy that hopefully will be more successful in Ireland. Now, the other strategy that Isabel and Siri have alluded to is the issue of guidelines. We have clinical guidelines, and here the WHO guidelines, the guidelines that is in the second edition, and I gather a third edition is coming out. I thought it was going to come out this year, but maybe it's delayed because of COVID. But the guideline strategy is something that I think is extremely important. Not only sort of policy guidelines, but also ethical guidelines. And let me take them in order. Siri mentioned South Africa, and they have, and I gather the guidelines, and I'm sorry Isabel had to leave, but it would be useful to follow up with her to understand the guidelines that were instituted in Colombia after the 2006 decision, to see what a difference they actually made. I think they brought the decision closer to people so people could understand. That's how I understood what Isabel was saying, but following up with her directly would be informative. So those guidelines, I think, can be very helpful. Siri mentioned the guidelines in Ethiopia. I gather in 2019, 2020, South Africa has developed guidelines, policy guidelines for delivery of services. I don't know much about how they've been done, but I think they seem to be extremely important. They are alluded to in the brief on comparative law that I sent you, that has been filed in the Mississippi case that will be heard by the US Supreme Court. So connecting directly with somebody like Charles Nguema, Professor Nguema, about those guidelines, I think would be very important. So those are policy guidelines in contrast to clinical guidelines. But let me go to the ethical guidelines. And here, I think there's a tremendous opportunity to use ethical guidelines, develop ethical guidelines, not only as a way of holding doctors' feet to the fire, but for training purposes of new doctors. Now, I know it's very hard in some countries, as Siri kept reminding us, things are very contextual. Some countries, it's very hard to work with doctors. They're patriarchs. I don't know what the situation is in Argentina, but if you have even a progressive nursing or a progressive doctor association, developing guidelines ethical guidelines can be very important. They can be, you can be very creative in these guidelines. You can adopt them very much the way the FIGO Ethics Committee has adopted guidelines. They even have a guideline around conscientious objection. They have a guideline, I think it's even called the right of conscience guideline. They have a guideline around harmful stereotyping. And this was in a period where they had quite a progressive ethics committee. I don't know what the situation is now, but certainly those guidelines are on the FIGO website and serve as models. Well, not models, they could guide you in the development of guidelines. If you have health associations that can develop these guidelines and adopt them. Now, why do I say ethical guidelines are important? Well, one is that courts do use them. The European Court of Human Rights in, I think it was the RR case, referred to the ethics guidelines of FIGO. And courts, if they're well developed, these guidelines, courts will tend to defer to them. Where I love this phrase that Siri used when there's, what was the phrase, sort of contests, moral contests. So courts are always looking for ways to duck moral contests. And if there is a well-developed guideline, very well thought through, courts will tend to defer to those guidelines. I have in the past suggested to FIGO that its regional, the Fabrasco, no, not Fabrasco, but the regional, what is the name of the regional FIGO group? They might be helpful in developing some of these guidelines. I've forgotten the name, but in the past, they've had very progressive people on that committee, and that might be another source. So those are some ideas on developing complementary strategies. I'll just end with another strategy that I think is useful in some countries, and you see it in some of the reasoning of courts, particularly the Portuguese decision, where there was a challenge by those opposed to abortion, and the court upheld the Portuguese law, the liberal Portuguese law. But the way they upheld it was very interesting. They essentially said that protecting prenatal life is a very important social value. Nobody would disagree with that. And they said that protecting prenatal life is best done through supporting the pregnant woman. And here in Argentina, what is the law that was passed on the same day as the liberalization of the abortion law that supported pregnant women who wanted to carry their pregnancies to term and gave them extra help? I thought that was a brilliant strategy because it showed that the movement in Argentina is not against prenatal life, but it's for women, either whether it's for choice, whether women want to have an abortion or whether women want to carry the pregnancy to term. And they supported those women. So I think that was a brilliant strategy and one that builds upon the Portuguese decision. You see it in the reasoning more and more. So those are three strategies around the right of conscience, the use of policy guidance, and the support of pregnant women, whether or not she wants to carry the pregnancy to term, to give her the support that she needs to be very patient or pregnant center focused.
Gracias, Rebecca.
Thank you, Rebecca. I have, sorry, I'm looking at my cell phone because I have the questions here. We had one more question from Amnesty, because I think you had a presentation, a PowerPoint presentation that we didn't show. I don't know if you want to show you, you'll tell me later. The question we have for you is, obviously, the battle for the control over life and the bodies of women is waged, especially harshly around abortion. This is a battle that is quite harsh against abortion, and it manifests the violence exercised against women. And in this context, how does the international law on human rights, is it useful or has it been useful to push towards the battles of women from an intersectional outlook and access to abortion as an essential right to health?
Two responses to that. One is, I think in civil law countries, there's a doctrine that you only use the criminal law as a last resort. And it would be helpful if we could mobilize criminal lawyers to really figure out how we can make more effective use of that doctrine of only using criminal law as a last resort as it applies to pregnant women. You have criminal law is used for moralistic reasons. It's often used as the first resort, as a way of condemning women for even miscarrying. So how can we mobilize our thinking around using the criminal law as a last resort? I don't teach criminal law in the criminal law area, but my sense is that we could be using this doctrine far more effectively, not only in our courts of law, but in the courts of public opinion. How can we develop this doctrine in a way that the feminist movement can use it far more effectively? It's an old and very embedded doctrine in criminal law, and I think we could be using it far more effectively. The second strategy is, and this refers to a very important decision of the Human Rights Committee against Argentina, the LNP decision. As you know, the LNP decision against Argentina was against Argentina for denying abortion to an indigenous adolescent woman. And there's an excellent commentary by Shreya Attry in actually in the Nordic Journal of International Law, I believe, by Shreya Attry. I think I sent it to you. Analyzing that decision from an intersectional perspective and explaining why that was such an important decision for not only for Argentina, but for those working on intersectional discrimination. So you have a very valuable decision right there. Now, one of the problems I think our movement could be far better at is thinking about discrimination against pregnant women. We're advancing in terms of discrimination on grounds of sex, on grounds of gender, but we need to think about how we tend to suspend the rights of pregnant women, of women when they become pregnant. And there's some very good language in several decisions about according pregnant women rights. So I think using the intersectional lens to include the rights of pregnant women, as well as the rights of adolescent pregnant girls, the rights of disabled women, etc., to access the care that they need, including Indigenous women. Unfortunately, experience in Canada shows that we tend to use the criminal law very punitively against marginalized women. For example, in Canada, it's embarrassing to admit, but when the court decriminalized abortion, we have no criminal law in Canada. The healthcare providers took it on their own to develop their own informal rules to give themselves license to punish our Indigenous women. And one of the things that they did was to deny anesthesia for those seeking abortion, Indigenous women. So I think there's lots to learn about how we go forward in terms of ensuring that all pregnant persons can access the services they want. The final strategy, I think that's very important that relates to Canada, is the use of medication abortion. We were late in Canada. Our law was liberalized the Supreme Court decision was in the 1988, and we only approved MIFI-MISO medication abortion in 2017. And this was the brilliance of our Wendy Norman, who wrote an article with Dorothy Shaw, the past president of FIGO, about what has happened in Canada with the use of MIFI-MISO. Under the conservative government, they had all sorts of restrictions on the use of medication abortion. But under our current liberal government, now prescriptions can be provided not only by any physician, but a nurse practitioner. And we now have the wide use of telemedicine. Now, of course, there initially were, as is often called, a mismatch of regulations around the use of medical abortion, but really zeroing in on how medication can be facilitated is absolutely critical. Something, what I call, is how do you push the practice? And here I highlight a book by Elizabeth Romanes and Jordan Parsons that just came out. In fact, yesterday or the day before, there was a wonderful Zoom workshop on it. And it's looking at how the US is restricting early medical abortion, and especially through telemedicine. So that is an area that's very contested, but if you can get out in front and get MIFI-MISO widely available, it can make a huge difference, not only in pushing the practice, but figuring out how to push the norms. Women too, pregnant women too, have the rights to the benefit of scientific progress.
Gracias, Rebeca. ¿Por casualidad tenés el nombre del libro o no los pasas?
Thank you, Rebecca. What's the name of that book? Can you share that, or have you already shared it?
Sure, it's in the PowerPoints. It's called Early Medical Abortion, Equality of Access and the Telemedical Imperative. It's Oxford University Press, and it's just out. They also have an article in the International Journal of Gynecology and Obstetrics, which is available on our website.
Súper útil, muchas gracias. Bueno, vuelvo a Siri, tengo preguntas para...
That's very useful, thank you so much. So I'm coming back to Siri now. I have a few more questions for her, and then questions from the audience. And we're coming up to the end of our meeting, but the questions I left with you, Siri.
Thank you. Very, very good questions. But I also want to just thank you, Rebecca. It was really, really super interesting to listen to you, and so many insights. So thank you very much. So yes, I think you're so right. And I think that there is a lot of inspiration. There is a sense in Norway and the Nordic countries. I mean, some have already moved to 18 weeks of abortion on request. And that is sort of that's very much a proposal in Norway now that sort of slimly failed, but probably might happen within the next couple of years, I think, with the new government. But of course, it's difficult because it is a negotiation issue. But I think there is clearly much. I think that. So it is interesting. I really, really liked, Rebecca, the sort of focus on women's rights. Sort of the women's rights to conscience, sort of the women's conscience, and I think that there is this debate around, partly I think around conscientious objection for health providers, it goes both ways in a way, this sense, and also sort of that if you take up a job in the public healthcare service, you already are committed to provide service equally, and that is sort of part of the ethics of the service that you take up. But I think that this was it's interesting, and it complements this thinking around the pregnant person's autonomy that is so, of course, very strong, and sort of the strongest argument. But I think that there is that's something that it's a very compelling point, and also the discrimination point, which is also part of the debate. But I think it is very much sort of this idea that in a situation where almost no abortions are denied that are after the sort of fair period of abortion on request. And I think that this sense that why should somebody else take the final decision? Why should that is sort of being very much questioned, and that there is probably going to be an extension. And I was really intrigued by this. But just to say that I think that what triggered this sort of we need to go to 18 weeks was an attempt by the Conservative government in alliance with the Christian Party to limit, to sort of restrict in a limited way abortion rights, and as part of a political deal, and that sort of triggered what is probably going to be an extension to 18 weeks. I think that the question of whether sort of when Argentina can do it, why not other Catholic countries? And I think that is a very I think that's a good question, and some, of course, we see that Ireland did, and I think that obviously the weakening of the Catholic Church due to a lot of scandals in many countries has in part paved the way, and also a more secular public sphere. I think that what is complicating it in many cases is, so it's not only the Catholic Church, and in many cases they're not the most radical. It is and I think that the religious competition between evangelicals and Catholics, and also others, but in particular, I think that the evangelicals coming in and sort of expanding a lot in many countries in Africa and Latin America is something that makes everyone makes all the churches, or most of the churches, more sort of firm on moral issues like abortion. So I think that is part of what we're seeing in some countries, and that make it more difficult. So besides so that it's sort of in some ways, in many places, even in countries where the Catholic Church is strong, it's sort of maybe less sort of the strong hand of the Vatican than the competition from a growing evangelical church that is making it difficult. So I think that it's very contextual, but I agree, and I think that there is absolutely an inspiration that is also happening in many countries. But if you look at Poland, for instance, it's a different context. So it's a different battle, because the politics of religion is different, at least for now. Maybe it will change.
Bueno, agrego una pregunta del público. Dicen, hablaste mucho.
We have here a question from the audience. You spoke of strategies and how anti-rights movements make our speech their own. How can we expand Argentina's experience to other countries? What actions can be taken to inform all movements all over the country of our strategies and use them in their favor?
So that is where I think that the sort of, in a way, the sort of may, of course, you use strategic litigation, but you also use so many different arenas and tools for social mobilization. And I think that the awareness of the sort of green scarves, the sort of broad feminist movements, but also sort of the broad social justice movements and the dialogues, as in Ireland. I think that the deep rooting in society of these debates, where it's about rights, but it's also about sort of the discrimination, the injustice done to particularly to large parts of the population and certain vulnerable groups in particular, that we have sort of these maturing political debates. And I think that is something that really, really is a lesson to draw, that it might to sort of that it's possible to go what might seem like a really long process, that it's actually possible that it can happen historically in a very short time, and that it is, and I think that this is very so I think that every woman and man and every person of any gender who experienced the past years in Argentina, that will be a formative experience for their life. That is something that will be that is something that when this is put under pressure is going to be activated in many people, and that is going to have sort of that this is the more sort of durable and lasting effect in society than maybe I think that is something to be learned. I think it is very durable, and I think that since rights are something that we need to sort of continuously be aware of, I think that to have this complementing the more narrow legal strategies, to use all, but to really sort of make sure that the social underpinning is there is something that I think Argentina is inspiring. And also sort of the visual, also in Ireland, I think that the visuals of it, sort of just the sort of artistic expressions that the pictures that you have get in your head and that are inspiring, the music, the chants, that it's important. I think it is very important to speak to people in so many different ways, that you involve the intellect, you involve the sense of justice, but you also involve the emotions in different ways.
Gracias, Siri. Voy a la última pregunta, Rebeca, del público.
Thank you, Siri. Last question from the audience. And they say, Rebecca, you mentioned an opportunity to reframe rights from the privacy to the consciousness liberty. From your point of view, what's the positive implication of that? Rebecca?
I think by reframing the right of conscience to make sure it's not monopolized by doctors who want to use it to deny women access to abortion is very important. Also, reframing the right of conscience as if it were a women's right as well adds to our understanding of women as autonomous agents. It's part and parcel of being autonomous. And I think every time this issue of conscientious objection is brought up, we need to think about reframing it. And one specific instance where this was done was in the European Committee on Social Rights, where a group of doctors who wanted to provide abortions brought a case. It was really under labor law standards, that because so many doctors were objecting on grounds of conscience, they were overburdened, and this was unfair to them as a labor matter. So they brought a case and won, and the European Committee on Social Rights, under the European Charter on Social Rights, directed Italy to make sure that they had a supply of healthcare providers that could provide abortion. The other right that I think we need, I tried to allude to, but let me just be more specific. the right of women to equality. I think there are many, many ways that we could use this. And this is particularly important because the health sector, the health ministries need, have a great opportunity here to ensure that healthcare is provided equitably across all sectors of society. And they're being pushed, particularly because of the Black Lives Matter movement, to really rethink. And in the slides that I sent, I referred to there's a whole series in the Lancet of articles about backlash against racial equality. And I think we could use those. This would be a wonderful research project for some students to look at how the health sector in different countries is ensuring equal access to healthcare on grounds of race and ethnicity, to think about how that movement could be applied to ensure that women have, and pregnant women in particular, have equal access on grounds of gender and pregnancy. So I think there's a long ways to go in terms of applying the right to non-discrimination, particularly intersectional non-discrimination in the health sector. And that would be another fascinating research project. Maybe my friends at Torquato di Tello might be interested in doing this, in ensuring that women of all different subgroups of women have access. I think finally, we need to do it along developing an equal justice, a reproductive justice framework. We need a reproductive justice framework in our ethical guidance. And in particular, this needs to be brought into the training of medical students in medical schools, nursing students in nursing schools. And a wonderful project in India, really impressive work they've done in India, in Maharashtra State, of integrating gender perspectives into the medical colleges of Maharashtra is a real model, and we can learn from that. Now that's just integrating gender perspectives into all aspects of training OBGYNs. It's not just a one-off course, a one-off lecture, but it's really taken very seriously and integrated in a way that that really can transform the hearts and minds of medical students. Sangeeta Reddy, I sent again a site to that, to her work, but being directly in touch with her, I think would be hugely beneficial. So having a reproductive justice plan that includes looking at intersectional equality and the harms of intersectional discrimination from the vantage point of different subgroups of women, including adolescent women, I think would be extremely important.
Thank you, Rebecca. I think the last point you were mentioning was mentioned yesterday by Jamie. In her presentation, she highlighted this aspect. I don't want to go much longer because it's quite late in Norway. In Canada, not so much, but in Canada, we're quite close in terms of time. It's been extremely enriching. I've written a lot of things. We are working on monitoring the enforcement of the law, on looking at what the private medical sector is doing, what the private sector, public sector is doing. We're working on strategic litigation. You provided a lot of input or ideas, questions that will make us keep on thinking, give us food for thought. Thank you for your willingness. We admire you immensely. So we are more than thankful. As I said, we'll write down a report of what we talked about yesterday and today. This webinar will be recorded in English and Spanish. We'll be sharing it so that you can have it. I'll send you warm greetings. Thank you, Siri, for taking part at this time, this late hour, for
you.
having joined us even due to some complications. Thank you very much.
Thank you so much. And could I please have your PowerPoint, Rebecca? I would love to see it. It was, yeah, so many thoughts. I can't keep them all in my head.
I'd be delighted. Yep.
Lovely. Thank you so much.
Okay.
And thanks.
Bye.
Maria Eleanor.
Thanks. Bye. Thank you very much indeed.
Bye for now.